Hello, Don Rolfe here with Northwest Legal Planning, and I'm here to talk to you today about whether or not trusts are only for wealthy people or rich people. I got this question from a client the other day, and it's something that comes up again and again when I'm meeting with new potential clients. Just by the way, if you have any questions about this or any other estate planning topic, just reach out to me by going to myestateplanmeeting.com, and you can meet with me to get those questions answered either on the phone or in person. So, are trusts only for wealthy people? Well, to start off, to tell you, there are certain advantages that trusts give individuals that have amassed a lot of assets by way of tax planning and making sure that large inheritances are protected from creditors and bankruptcies and ex-spouses and all of those sorts of things. But really the factors that I look at as to what a trust can offer every person doing an estate plan are during incapacity, and then also simplifying distribution after you have passed away by avoiding probate. So during incapacity, once you've created a trust and transferred all of your assets inside of that trust, if something happens to you where you're no longer able to manage your own affairs, your own finances, those sorts of things, a successor trustee can step in and automatically have the power to manage all of those assets for you, to pay your bills, to make sure that your house gets repaired, all of those sorts of things, without having to go to court and get appointed as a conservator and a guardian to be able to do those things for you. So it's a savings in two ways. Number one, it's a savings that there's not the expense of having to go to court and figuring out who's going to be the conservator and possibly being someone that you wouldn't choose to be your conservator and take over your finances for you. So in your trust, you get to name who that person is, you get to talk to them in advance about whether or not they would want to do it. And it streamlines the process because you're not going to court, and there isn't going to be the court costs and perhaps attorney's fees associated with having someone be appointed as a conservator or guardian. On top of that, there's also no time delay. So immediately once it's determined that you're incapacitated, your successor trustee can step in and take over. Whereas if it's required that a conservator be appointed, there may be a lag and some things may fall through the cracks during the time that it's discovered that you may be incapacitated and unable to manage your affairs, to when they actually get into court and get a judge to sign the order to appoint someone that has the authority to take care of your things for you. Then, when you pass away, there is administration that has to be done, whether you have a will-based estate plan or a trust-based estate plan. But again, just like during incapacity, if you have a trust as opposed to a will, the court doesn't have to get involved in order to have your trust administered. So it saves probate. It saves you from having to go through probate or your heirs having to go through probate. And your successor trustee can step in, follow directions in your trust, administer your trust, having to do many of the same things they would have to do in a probate, however, without the supervision of the court and without having to pay court costs and those sorts of things. And then on top of it, a lot of people that are concerned that trusts are only for the wealthy, they're concerned that they don't need to leave their children their estate or their inheritance in trust because their children are more successful than they are, that they have a lot of their own assets. They're not really relying upon this inheritance. And that's a good thing. I mean, that's what we all want. We all want our children to be more successful than we were, right? I mean, that's why we put in so much work and effort in providing the best for our children. But even in these cases where the people inheriting are well off or are not going to be relying upon it, we can still leave their inheritance to them in trust. And I like to call this an I love you trust, because what it does is it takes perhaps a small amount of money and it puts it in trust for that child. And then when they use that money, they know where it's coming from. So if they use it to pay for the kids to go to summer camp, or take the family on a vacation down to the beach for a week, or whatever it is that they're using it for, they know when they write that trust check that that is something that is coming from mom and dad. As opposed to if it's just left to them outright, it gets mixed in with the family finances, it gets spent, but nobody ever really knows what it was spent on. And maybe 5-10 years down the road, the son who inherited the money may look to his wife and say, "Do you know what we ever spent that money that mom left us on?" And it'll be a mystery. So, that's a nice thing that you can leave for whoever your beneficiaries are, is that recognition of what it is that you've actually left them and that they've used it for. Again, if you have any questions about this or any other estate planning topic, please do feel free to reach out to me for a complimentary 30-minute strategy session where I can answer the questions that you have and talk to you about your options for estate planning. And you can do that by going to myestateplanmeeting.com. Again, my name is Don Rolfe. I'm the owner and founder of Northwest Legal Planning. And until next time, take care. Bye.